This is Helen.keit, the Keit team at Keller Williams Realty Landmark here in Queens, New York City. And as part of our little interview series, I want to introduce some of the professionals that we work with and recommend, really experts in their field. And I think we'll all learn something too. So today we have Donna Turetsky with us, partner at the law firm of Certilman Balin Adler and Hyman. And I'm going to just read you a little bit about Donna's background. Hi, Donna.
Hello. Hi. Thank you for having me.
Thank you for being here. Okay, Donna concentrates her practice on trust and estate administration, elder law, estate planning, special needs planning, and guardianships. Her clients rely on her for estate and tax matters. She prepares wills, revocable trusts, irrevocable trusts, supplemental needs trusts, power of attorney, healthcare proxies, and she really counsels seniors and their families, helping them with tax planning needs, long-term care needs, certainly Medicaid, special needs planning. And in the past years, Donna has been recognized as the top 10 legal eagles, recognized by Long Island Pulse magazine. And she was also selected as one of the top women in law by the Center for Children, Families, and Law at Hofstra University School of Law. So I welcome Donna here today. And I think probably what would be helpful is if we start really with an overview of elder law planning, and it's important certainly with the unexpected virus that's just taken us all by surprise. I mean, kind of highlight any scenarios or things that you've noted or your clients have felt, and I'm going to turn this over to you.
Sure. So thanks, Helen, for having me. It's been a really, really crazy, difficult time for everybody. And very upsetting to get phone calls to hear about my clients that have passed away over this virus. It's always very difficult to listen to it to begin with, but the number of phone calls that have come in over the last couple of weeks have just been really very upsetting. And I think that it's just important to note that there's certain things that are, would be, that should be in place if, God forbid, you in a regular situation, you end up in a hospital, or you need to be able to do your planning. So it's not just this COVID crisis, but planning should be done regardless, in every situation.
So what documents do you feel are necessary? What are the most important things, Donna, family?
Well, just to go back to even this COVID crisis, the thing working out well for us as estate planning attorneys is that the governor did issue an executive order allowing us to be able to do our planning remotely. So that was a really, really big thing, because originally a lot of people were calling us, and even now people are calling us because they want their wills done. They want their healthcare proxies done. They want their power of attorneys done. And originally there was no way to do it but to be able to actually be in a room with somebody and be able to, there's certain requirements in order to be able to witness and notarize things. And there have been executive orders now done so that, number one, we can notarize remotely. And number two, we can execute people's wills remotely. So that have just definitely changed the whole landscape of things and allowed us to do things for people that need to get done. People normally what they would, are calling me for is, number one, they want their wills done. They haven't done any planning whatsoever, and they just want to make sure that something's written down, that their assets are being left to who they want them to be left to, and that there are trusts set up for their children, who, a lot of times they have minor children and they don't want to leave assets. You never want to leave assets to a minor child. So that's been a really big concern of my clients that have been calling up. And so we've been doing planning for them so that their wills are properly done, they're properly executed, they have them exactly the way they need them, and they feel that it relieves a lot of stress in their lives. I also getting a lot of phone calls regarding healthcare proxies and power of attorneys. So people need healthcare proxies, because if you can't make your own healthcare decision, you want to be able to give somebody else the power to be able to do that. And and especially now with the situations going on in the hospitals, when even loved ones can't even go into the hospital, you want to make sure that there's a healthcare proxy in place so that the hospital administrators know who to turn to if you can't make a healthcare decision yourself. So, those are two extremely important, that's a very extremely important document to have. The power of attorney as well. You're going to ask me about that. So a power of attorney is a financial document. It allows someone else to be able to handle your financial affairs. So if you can't do those things, you want to be able to have someone be able to do it for you. If not, and somebody needs to be able to access your assets and doesn't have the authority to do that, they'll need to go through a guardianship proceeding.
And Donna, what would happen if somebody doesn't have a will, or even the will process? I think a lot of people don't understand the root, what goes on there.
So if somebody does not have a will, what happens is that it's called an administration. So when a person passes away without a will, if they have a spouse, then what the New York State statute says is that everything goes to the spouse. You still have to go through the courts. You still have to file an administration petition. And if there's only a spouse, you file a petition, you get an administrator appointed, and the assets will go to the spouse. What people a lot of times don't realize is that when you don't have a will and you have a spouse and children, a lot of people, and this is before the COVID crisis even started, this is just in general, I've had this situation many times in my office, people don't realize that the assets all don't go to the spouse. Because what happens is when you pass away with a spouse and children, the laws of intestacy, the New York statute says that the first $50,000 plus 1/2 of your assets go to your spouse, and the other half of the assets go to the children. So what that means is that if, we've had clients come in, unexpectedly, their spouse passed away, they have a minor child, the house was in the name of the person who passed away. And we have to explain to a spouse that the whole entire house she doesn't have full ownership of it because there was no will and it was in her husband's name. So that's always been a real, surprise, and a reason why people should do their estate planning documents, because we know that wasn't the intent. I'm sure the intent was probably for if spouse passed away, it goes to the other spouse, not that it would have to go to the spouse and the children, especially if there's minors, because if there's minors, then there's other hurdles that you have to go through, because you have to do guardianships and everything.
Now, what about trust, Donna? I know people always have questions on that.
All right. So I just, to go back one more about administration.
Mm-hmm.
When you have a will, I just want to explain the difference between the two. When you have a will, and what happens is you name someone as your executor, and then you can go probate. We have to probate a will with the court. So if somebody passes away, you name somebody as an executor. We have to get certain waivers and consents from people. And assuming nobody contests to that person be appointed to the will, to be the executor, and that they agree the will is fine, the will be admitted to probate. And so you need to still go through a probate process with wills as well, but you've appointed an executor, and you've appointed, how you want your assets to be distributed. And that's the importance of having that kind of document.
Does the executor necessarily get, I know there's always that debate, if it's a family member, do they necessarily get paid? Somebody outside would get paid as an executor? Yes, no?
So the executor is entitled to executors' commissions, and they're statutory. So the answer is it's in the statute, and there are commissions. If it's a family member, a lot of times they don't take them, because they're income taxable and they may be receiving everything directly themselves anyway. If it's a non-family member and they're acting as a fiduciary, they may take them, and they're entitled to them.
The importance of planning. I'm sure many people got caught off guard with this. All of a sudden they're ill, right?
I think a lot of people really did get caught off guard. And I think that unfortunately, this crisis put a lot of light into, doing your planning properly. What's interesting is that, we do a lot of wills, and there's certain circumstances that we would recommend something called a living trust, and otherwise known as a revocable trust. So there's certain circumstances that we think that it's important to have a revocable trust, but not in all circumstances. And what a revocable trust is basically a document that's a trust agreement that you do while you're alive, and it's fully revocable. And you put, you pretty much in your revocable trust state when you pass away what happens to your assets, but during your lifetime, you could use the assets during your lifetime. You can change the revocable trust when you need to, and you name your trustee so that when you fund your revocable trust, if you pass away, the successor trustee automatically has control over your assets that are in the trust. And I think that's a really big thing right now, because seeing what's going on in the world with this virus, I think that it sheds a new light on why people may want to decide doing revocable trusts versus wills. Because a revocable trust, you don't have to go through the courts. If you fund your revocable trust, your assets are already in the trust. So if you pass away, your successor trustee automatically has control over them. And right now, what's going on over the last couple of months is the courts were closed, or the courts were very limited, had very limited capacity. So we're having a lot of trouble getting probates through and certain things done in order to get executors appointed with the wills. So I think it really sheds a new light now on maybe rethinking what kind of planning documents you may want to have and what may be more appropriate for, individuals in general.
Sure, I'm sure this is going to highlight like the new normal, the way we'll have different aspects of our business. I mean, I can just see planning is going to be so crucial now. Anything about, I know you do special needs planning, certainly working with families on long-term care planning, that sort of thing.
So we do a lot of long-term care planning and special needs planning. We in our documents with the estate planning, we also include supplemental needs trusts. A lot of people, have come in over the years and said, I have a disabled child. I don't want to leave anything to them because I'm afraid that they're going to, they have Medicaid or they are on government benefits, and I'm just not going to leave anything to them. And they don't realize that you can leave assets to a disabled individual. You should not leave it to them individually, but you can put it into what we call a supplemental needs trust for their benefit. So the trust could be used to supplement, not supplant, any government benefits they might be receiving. And that's been an eye-opener for a lot of clients that have come in, because they'll say to me, well, I'm not going to leave anything to my son because, he's getting benefits. I'm going to leave it all to my daughter. And there's a downside to that, because you don't know if you leave it to everything to the daughter, whether or not, what's going to happen to her, down the line. So I think a lot of people, once they hear that they don't have to disinherit their child, they can leave assets in a supplemental needs trust for the child's benefit. I think that relieves a lot of their anxiety about once they pass, that they could fund a trust for their benefit. As far as long-term care planning, I mean, there's different types of tools that we use. We use irrevocable trusts in doing some kind of long-term care planning. We'll do an irrevocable trust, which we may put a residence into an irrevocable trust. Once a certain period of time goes by, the trust is protected, and different types of techniques that we could use in order to plan and protect people's assets.
This just shows me there's so many questions that people really have to formulate. Each situation, I'm sure, is different. How often do you advise reviewing what you've set up? I know
we usually recommend reviewing it like at least every 5 years. At least every 5 years, because you never know if the power of attorney form, that form hasn't changed in a while, but some of the tax laws change, your situations change. People put designations on accounts, which they didn't realize. Once you do that, if you put a beneficiary designation on an account, it doesn't pass through your will. So it's always good to have like your documents looked at every few years in order to make sure it's appropriate for your type of situation, down the line. And if people's lives change, people's situations change, their financial situations change, their kids' situations change. We're very big believers in trusts. So when we set up our wills or our revocable trusts or any documents we have, when assets are left to children, we like to use trusts in order to have the assets distributed to their trusts versus it just distributed to them outright. So that, we have a couple, if we have somebody passes away and they leave all their assets to their 3 kids, instead of the 3 kids getting the assets outright, and now it's part of their own taxable estates, it's subject to their, they could be subject to their creditors, or if they need planning down the line themselves, It's all subject to all those things. You could put it into a trust for their benefit, which could be used for them during their lifetime. And they could be also in control of the trust along with a disinterested trustee. And it's a good planning device for individuals to be able to protect their assets, and also for them to be able to continue having their assets, continue in a trust.
This just shows me how many things we don't all know. I think a lot of times people put off doing a will. They're afraid to face these situations and try and decide, going forward. But I mean, this is necessary. Something like what's just happened has thrown a lot of people into a situation they didn't prepare for, right?
Yeah, I mean, I believe it's always been necessary, but but I think people do, some people do put it off. So I have a lot of younger people say to me, they put it off because they can't think of who they want as the guardian of their child. And, I always say that's a silly reason to put off doing your estate planning, because God forbid something happened to two people, to a husband and wife, and they have a minor child. You want to make sure that the assets that you're leaving your children are left in trust for them, that you get to pick who you want to be in control over that trust. You never want to have a minor child ever receive assets outright, because what happens is if a minor child receives assets outright, somebody needs to go when somebody, in order to get access to those funds, has to file for a guardianship proceeding with the surrogates court. And if they would have properly done, a will or a revocable trust, and they would have set it up so their children receive it in trust for their benefits, then they could have chosen who they wanted as their trustee. They could have chosen how the assets would be distributed out to their kids and when they wanted their kids to receive everything. So it's so important for everybody. I tell people, young, old, it doesn't make a difference. It's so important to make sure that you have your planning documents in place. I'm also a really big believer in having a solid, good power of attorney, because during your lifetime, things happen. We see that now. And if you have assets that are in your name and you don't have the capability to be able to, if you're in a hospital or you're in a situation or you have a stroke or something, you want to be able to appoint someone you trust, because it's a fiduciary responsibility. It has to be someone you trust to be able to access your accounts and be able to pay your bills and your expenses and take care of you. It's such an important tool. Power of attorney is only good while you're alive. Once you pass away, it's no longer good. It ceases once a person passes away.
Okay. Donna, this is so helpful. I'm going to put Donna's contact information attached so you can all reach her. Invaluable information, really. And something to all think about going forward. There's so many questions and it's become very complex. So I can't thank you enough. We thank you. I'm going to have this ready and everybody will be able to reach you.
Thank you, Helen. Thanks for having me. Bye-bye.